No listed. Find out. Any German serial number 125 under the heading of Reserves and Office Notes, serial number 2. I see similar to this.
Number 2.
Under the heading orders and office notes.
2020 matter. Still
there is no similar that the issue is
let us see.
Led by the council, therefore it is difficult.
2020 matter.
Item number 4.
Item number
4. Pass.
Item number 3. Which is for institution file करना
let us specify.
Any between serial number 216.
Serial number 2.
We'll have 4 more time because I think something momentum.
I will inform the other sir.
Yes.
4 weeks.
50 may come on Monday. 50. 50 Monday.
Yes.
And here they are between serial number 17 to 26.
Serial number 7.
Serial number 24 weeks time.
Yes,
20.
Serial number 24. I will
it is all an
yes, Mr.
20 has graduated.
24.
24.
It was 20, 24.
I will.
All right. What do you want? Today it's you can't start the date and time. If whenever it is released, mention. Yes.
Item number 23 may apply for 2 weeks time.
Yes.
Wait. Any between serial number 77 to 37.
7 my
27 password.
37 my 1 week time.
37. Yes.
34. 1 week time.
34.
29 and 1 week.
Yes.
My lord, 2 weeks का दिया है for 27 my lord, 2 weeks my lord. He corresponded time for 2 weeks. 29.
Yes.
2 weeks my lord.
And here between serial number 38 to 45. And here between serial number 46 to 48. And the heading to be concerned serial number 1 by Construction Private Limited versus the State of Bihar for the petitioners Sri Sasi Ranjan Kumar.
Lordship.
I apply for the December 26th for drawing.
Withdrawn.
Gratefully.
Under the heading of serial number 2 Varia versus State of Bihar for the petitioners Sri Ranjan.
Yes, sir. Maintainability of the.
Yes, my lord, sir. That is why my lord, I am seeking. I am led by Mr. D. inside, my lord. He is to assist my lord. No difficulty, therefore I am seeking for 2 weeks time. Any of the matter, my lord,
Interim maintenance is under which provision?
that is the certain matter we have not even filed any petition for maintenance. The application before the board was under section 26 of the Domestic Violence Act.
26, sir?
The Domestic Violence Act.
What was the ultimate order?
Ultimate order, my lord, was rather giving any finding regarding whether there was any domestic violence constituted or not. The judge may not proceed to make who not treat it as a maintenance petition and cannot directed for payment of interest. There was no prayer at all because even otherwise, the domestic violence penalty in terms of section 27 will not be in addition to the other reliefs available to the petitioner. So, scope of treating that is.
Filing the petition. Huh? No. Original. Supervision and control. All right, get ready by next week. The request of the council from the petitioner. We release this matter next week.
Through this time, we will get to calling limitation difference.
Rectify the officer section. Limitation.
Another limitation is required.
What is the date of the
Airport order? Yes. 36/2021. 36. It is showing.
36/2021.
Yes.
25 days.
10/8/2021. 8. Under the family court act, the limit is 30 days.
It's 90 days. No, family court, section 19 says for 30 days. But at the same time, two management act.
Yes.
That interpretation is given in Savitra Pandey case. Savitra Pandey, Savitra Pandey.
Only says 30 days. Family court act says 30
No, family
days.
court act read with Hindu Marriage Act 1955 interpreted by the Supreme Court in Savitra Pandey case. 84 of 1. You had that 1955. Split 1954. Correct, but 28.4 has been amended in 2003.
Section 28. Section 28.
No, the office of the office of reservation. The representative, MA. 474.
Yes.
474 of 2021. Is not supported by interlocutory application for control as which is beyond 90 days with reference to section 3 of section 19 of the Family Body Act 1984. No, section 19 within bracket 3 of the Family Body Act 1984 stipulated 30 days to file a. At the same time, it is necessary to make note of section 28.4 of the Hindu Marriage Act 1955. Both these sections reads as an apex court in the case of Savitri Pandey or Phule. Take a note of the aforementioned section. And interpret consumption of non-absent of law. Non-absent section 20 of the Family Court Act 1984 read with the provisions of the Hindu Marriage Act 1955 and it held that section 19.3 stipulation of 50 days is required to be read down as 90 days in the right subsection 4 of section 28 of the Hindu Marriage Act 1955. Identical matter was a subject matter of only honorable subject matter of the case of so and so very elaborately dealt earlier various courts like Allahabad, Bombay High Court and so on. Supreme Court decision in the case of Savitri Phule. And finding has been given that the High Court shall not insists that appeal should be filed within 30 days. And it has to be read as the limitation period for filing miscellaneous appeal against the family court order as 90 days. Accordingly, office objection related to non-filing of a limitation petition is hereby overruled. The registry is hereby directed to take note of the present order read Sabri Pule and decision of the Jhatka High Court in the case of so and so. And provide and give proper direction to the exclusive branch of the constitution section not to insist limitation petition. If miscellaneous appeal is filed within 90 days from the date of within 90 days, copy of this order shall be communicated to the High Court Legal Service Authority. In this regard, necessary notification on administrative side shall be issued by this court. A notification or amendment of any provision very this is matter when you want after 2 weeks. Keep this copy. If required in some other case, we just post this.
This is not challenging order, and the Lordship were satisfied that as to why the petitioner was employed of the Central Reserve Press Force, and then the Civil Services Act rule has been applied. But subsequently, from the Lordship side, the question arose to me, my Lord, as to whether the petition itself was maintainable when the cause of action for the first dismissal order passed within the state of West Bengal. And writ petition has been filed in India. Now, I submitted before Lordship the 3 grounds that it was served upon me in Bihar. Secondly, I was ill. And thirdly, writ petition, no objection was held. So, my Lord has not guided us. 2014 or 9-329 Kishore Sharma case. 3 paragraphs are relevant. Paragraph number 17, 18 and 19. I will place only.
Have you produced the order passed in Astos Ranjan versus Union of India? Last time we have requested you to go through that.
I noted down one level case of very sorry.
No, we have specifically quoted the decision also.
Yes, Lord. Supreme Court.
Why you did not?
Supreme Court.
In that decision, we have quoted the number of Supreme Court decision. If I am correct.
Yes, madam. Right.
Then go through and come back. Because you have to convince us. This is our my order, or I don't know, single judge or division bench. Is it division bench or single? Single. Therefore, my order is correct or not. You have to apply this code in order to overrule or to apply the license judgment.
So my lord asked for that about resources markets that I have.
Correct, but at the same time, we have quoted the decision. In this decision, we have quoted the keep on.
Serial 6 start infra project near the
I confine this application not only for unit number 1 by which my lord this interviewer had devoured the petitioner. Only relief number 1, my lord, that is the debarment order. Yeah. My lord, annexure 8 page 41, my lord. The executive engineer has debarred the petitioner without giving any notice and for indefinite period, as well as the executive engineer has not requested to pass one step of my lord, can you see annexure 8 page 41, my lord.
Yes, sir. What do you say?
That apart, my lord, he has filed an affidavit, my lord, in which he has stated, my lord, that he confines himself only to the debarment order, as well as he has mentioned, my lord, that the project which has been extended is on the verge of completion, my lord. So I say, my lord, that debarment is not, my lord, blacklisting. Debarment is project specific. As soon as it is completed, my lord, debarment automatically goes. As far as debarment is concerned, my lord, he
simply set aside.
No, my lord,
but he's not in compliance with notice and other
notice has been given.
So as the notice that indefinitely your future. What is that? Future tender. You are not supposed to participate in future tender.
Up to the you complete the project, my lord.
Oh, where is that word?
My lord,
where is the word in such word in Annexure P8?
My lord, we come to Annexure D, page 53 of the show.
You have to go by P8. In P8, indefinitely you are asking him not to participate in future tender.
My lord, we come to paragraph 33.
We go beyond P8.
No, my lord. I'm just explaining, Lord, that has been taken here in paragraph 33, where I say, Lord, in Bihar Contractor Rules 2007, it is not blacklisting or it is not suspension. It is only that is debarment. Debarment is as in terms of a circular which says that, Lord, the project is project specific. As
source of power, debarring a contractor for future tender.
Lord, just pass it over. I will bring a second.
After few cases.
No, Lord. I mean pass over for the day. I will just only, but we not.
You have to identify that source of power.
Yes.
Further asking us to prohibiting into not to participate in future tender.
Only till he completes the project. Okay, blood I will satisfy.
And also notice.
Yes.
Notice only specific. We have to define
Mechanically notice.
I will bring that circular.
Not in this case. The petitioner is filed, Your Lordship, because the petitioner was blacklisted on 20/8/2020, Your Lordship, by the Mysore 1. Your Lordship, the contract was given to the petitioner, Your Lordship, and the letter of that was cancelled on the basis of the inquiry report as mentioned in the counter affidavit, Your Lordship, and the counter affidavit filed by the state. It is also apparent that they have issued one show cause notice dated 30/7/2022, but in reply to the counter affidavit, Your Lordship, the show cause notice dated 30 July 2020. They have stated in the counter affidavit, but
have you submitted your reply?
Lordship, I have never received any show cause notice. And from the order sheet also, from the blacklisting order, Lordship, which is Annexure 1, it is only mentioned that one show cause notice was issued. It is not mentioned in the entire order sheet whether the same
show cause notice indicates that there is a proposal for blacklisting you for 10 years.
Lordship.
Show cause notice dated 30th July 2020 indicates that you will be blacklisted for 10 years.
10 years. Yes. They said it, Lordship.
But it has not been communicated to you.
Yes, and the show cause notice is Lordship, which is in Excel RH. RH may kindly see. In Excel H.
File the response of 1 to 5.
Yes, Lordship. Page 32 of the counter affidavit, may kindly see. Page 32 of the counter affidavit. They have not given me the indication that you are going to be blacklisted for 10 years. They said in this show cause notice. Yes, Lordship. They said this is this show cause notice. And the second last paragraph I am reading, Lordship. उपरोक्त तथ्य से स्पष्ट है कि आपके द्वारा निविदा में गलत कागजात को संलग्न करने के लिए और निविदा का निष्पादन आपके द्वारा किए गए ट्रू एंड वैलिड शपथ पत्र के आधार पर किया गया है। स्पष्ट है कि आपके द्वारा गलत शपथ पत्र किया गया है। Means the affidavit which I have filed for the authorities at the time of tender was found false. This was the allegation. So the fact is this show cause
this show cause notice indicated the proposal for blacklisting you for 10 years.
No, Lordship.
It was immediately asking you. This has not been served. No. First of all, whether it is served or not. Secondly, the show cause notice does not indicate the specific period. Proposal for blacklisting.
No, that is not the specific period because it is up to the competent authority, who is the engineer-in-chief, my lord. The show cause has been asked by the executive engineer on the basis of the full document that he prepared.
No, all right.
Now, my
whether this notice has been served on the petitioner or not.
executive engineer has served the notice.
Sure, definitely.
Receiving and all that.
Not right instruction.
No, by
Where and insurance are your period?
Yes,
so far is not served on.
Yes, Lordship, the rejoinder I have filed, which is on page 3. Page 3, Lordship. Lordship, after the fourth line, Lordship, I am reading this paragraph. The petitioner submits that he has never received any show cause notice. She has noticed by the respondent with regard to the inquiry. Paragraph, Lordship, continuity, paragraph 7. I am reading page 3.
the petition is not with me, my lord. I'm sorry, my lord.
Page 3 is not the paragraph 7 is
I'm just reading. Paragraph 7 is the reply of paragraph number 716, page 2. Page 2, paragraph 7. Lordship, then continuity, page 3 on page 3 may kindly come. After 5 lines. In reply of this paragraph, the petitioner submits that he has never.
Read paragraph 7. Paragraph 7 starts by letter dated 12.
Rejoinder, my lord, is looking for what? I'm talking about the rejoinder which I have filed.
When did you file?
Yesterday, Lordship.
Then how do you expect that this will be?
Let us see that is on the record, Lordship. Or it might be taken up tomorrow. I will argue tomorrow, Lordship.
What is your count, Mr. What is your counter to paragraph 6 of your petition?
That is not given the paragraph advisory.
Huh? What is your reply?
The paragraph reply is not there, my lords, but
order sheet has been taken. The order sheet has been taken, that the show cause has been asked, and that has not been.
Correct. When she has stated that no show cause is served upon him. Where is the reply to this in the counter affidavit? It has been served, sir. These are the documents. Petitioner signature is for the so as
I have said about the show cause, but on the receiving, whether that has been served or not, that is on that one.
merely statement is not sufficient. When there is specific attention is done.
In reply of the counter question, may I pass a final question?
My lord, I'll reply to this agenda. Just now I've got this.
No, in para 6, the petition itself
Yes, my lord, that has been replied in para number.
why mere statement is not sufficient?
After this so-called
And in the so-called there is no proposal for 10 years blacklisting. That is sufficient. You will allow the petition.
My lord, my only submission is that once the fraud has been committed, my lord, the other rights has been already.
Sir, already we will give you liberty for fresh.
they have already tendered. They have already allotted and tendered for other purposes.
Furnishing false affidavit is concerned, that is required to be examined.
And another thing, Lordship, the counter reply of the counter has stated after the issuance of so-called notice dated 37/2022, they have entered the work which I had done approximately about 9 lakhs in the measurement on 5/8/22. The measurement of the work after getting the tender, I have done some work and they have entered.
You claim under the arbitration clause.
That is there, Lordship. But I have tried this only to show that I have never received any notice.
Yes, later on in the instant petition, petitioner has prayed for the following. The petitioner is a successful bidder in respect of a particular work. So it is reliable that the petitioner has executed certain works. At that juncture, the respondent notice that the petitioner is alleged to have filed a false affidavit. By taking note of the alleged filing of the false affidavit, notice has been issued on 30th July 2020. Annexed R overhead. Thereafter, proceeded to blacklist the petitioner for a period of 10 years. On 20th August 2020, hence the present petition insofar as challenging blacklisting and consequential orders. Police Shobha Notice dated 30th July 2020. It does not reveal specific notice of blacklisting the petitioner for a period of 10 years. Further, the petitioner has contended that it has not been served on the petitioner. While para 6 of the regulation. On the other hand, the same has been countered. Merely stating that Shobha Notice dated 30th July 2020 has been served on the petitioner without producing material information. So as to meet para 6 of the regulation. Even if the petitioner has made out the case, since Shobha Notice dated 30th July 2020 is that type of material information like proposal to blacklist the petitioner for a period of 10 years. To suppress in the case of so and so. Had Shobha Notice was very strict insofar as the blacklisting are debarring the contractor in the right action circumstances, the minister has made a case and it is so reserving the petitioner, sorry, respondent, respondent. Initiate proceedings is warranted at this stage. Such a proceeding shall be completed after 4 months date of the order. The concerned authority hereby directed to take note of judicial decision contained in the present order before proceeding further can according to the resolutions and follow.
Serial number versus Kumar Abhishek Construction versus the Secretary of Administration CFO Kumar.
May please, Your Lord, serial number 10 and serial number 11. Both are parties are same and similar, and for the person are all same and similar, but correspondents are similar. Some different date of orders. Lord, order number 7, dated 14/3/2030. I am filing Lord supplementary affidavit in compliance of order, Lord. So it may be accepted. I have already filed online, Lord. So copy has already been filed. Hard copy may be accepted, Lord.
What is the document you are producing?
My Lord, hard copy may be accepted, Lord. I have sought information to right information Act, Lord. That is Annexure 35 at page 9, Lord. Internal 9, Lord. Today, supplementary affidavit. That information has been provided by the department to the RTI, Lord. उपयुक्त विषय का प्रश्न कहना है कि आपके द्वारा मांगे गए सूचना पत्र कब है इतना जो संवेदक द्वारा काली सूची के स्पष्टीकरण के जवाब में अभियंता प्रमुख ग्रामीण कार्य विभाग पटना के
What you asked from the department? Which information you sought from the informant?
Lord, I sought information कि हमने जो लाइन फाइल किया तो पहुंचा उसकी कॉपी हमें उन्होंने दिया है.
Copy will be made available to you because
they have accepted that this letter was received in the office of.
Where is that statement?
That statement is Annexure 35 at page 9. At page 9. संवेदक द्वारा काली सूची के स्पष्टीकरण में they have accepted
Don't mislead this word. These are nowhere they are stated in Lecture 35 that they are in the receipt of your reply. What is they have stated? Records have been gone.
Records have been हम पढ़ के सुनाते हैं जो संवेदक द्वारा काली सूची के स्पष्टीकरण के जवाब में अभियंता प्रमुख ग्रामीण कार्य विभाग पटना के कार्यालय में प्राप्त हुआ था मैंने वो रिसीव
नहीं वो नहीं है. आप कह रहे हैं कि जो हमने जो दिया है उसके आप दीजिए रिसीविंग वगैरह जो भी है. इसलिए आपसे पूछ रहे हैं कि आपने क्या मांगा था.
लगाए हमारा आवेदन
नहीं है कि
आवेदन लगाए हैं कि अभिषेक कंस्ट्रक्शन द्वारा लेटर नंबर 11 dated 4/9/2020 की प्रति चाहिए, छाया प्रति चाहिए। हमने स्पेसिफिक इसमें वही लेटर मांगा है।
Give extra this copy, case 35. Give extra this in the order stating that you contain that you have furnished, replied, and they have admitted. But according to us, this is not the admission.
My lord, इसमें word has कुछ संशय सुना दे रहे हैं। इसमें वर्ड बुजुर्ग देखा जाए सेक्शन में कहना है कि आपके द्वारा जो अपने प्रपत्र फल में इतना जो मांगी गई और जो सीधे लिखा हुआ है वो संवेदक द्वारा काली सूची का स्पष्टीकरण करने जवाब में अभियंता प्रमुख ग्रामीण कार्य विभाग पटना के कार्यालय में प्राप्त हुआ। उन्होंने ये एडमिट किया कि प्राप्त हुआ, लेकिन एक्ट कर दिया that document has burned in
words of your own, which is not reflected in the communication.
कम्युनिकेशन की ही बात कर रहे हैं। जो हमारे
will pass an order that you are misleading. You can't document.
I am not misleading this.
Nowhere the document says that you have submitted and it has been accepted.
इसी से इंग्लिश ट्रांसलेट करवाया जाए कि जो संवेदक द्वारा काली सूची स्पष्टीकरण के जवाब में अभियंता प्रमुख कार्य विभाग पटना के कार्यालय में प्राप्त हुआ था तो हमने नहीं मांगा है, हमने तो लेटर मांगा। हमारे एप्लीकेशन में देखा जाए कि लेटर नंबर 11 KC 2020 दिनांक 4/9/2020 का हमने लेटर मांगा। हमने ये नहीं मांगा था कि आपने यहाँ हमने ये नहीं मांगा था कि आप यहाँ प्राप्त हुआ, हमने ये मांगा था वो लेटर। तो लेटर में इन्होंने रिप्लाई लिखा कि प्राप्त हुआ था।
सर आगे यार तो पब्लिक लास्ट में प्राप्त हुआ कैसा है?
Not permitted to allow other facts.
No, first you furnish a copy of the RTI information.
That is on record. Mechanism Lord Enacted 34, page 7 मिलो। लास्ट लाइक जो हेड राइटिंग में लिखा हुआ है कि मेसर्स अभिषेक कंस्ट्रक्शन द्वारा 11 KAC 2020 दिनांक 4/9/2020 का छाया प्रति चाहिए। हमने ये नहीं कहा था कि आपको दे दें, छाया प्रति चाहिए मैंने कहा, मांगा वो कॉपी। छाया प्रति चाहिए।
That copy you have already submitted that you are having that copy. So why you are asking for
this was because of that copy it was not proper receiving of the authority. तो हुजूर का इसी पर आदेश हुआ 14 तारीख का और ये 14/3/2013 इस पर रिसीविंग नहीं है, इस पर रिसीविंग नहीं है, हमने तो एनेक्स किया।
State Council, the Annexure 35, the assistant engineer says that document was प्राप्त हुआ मतलब क्या? What is the material information while making such statement?
From this annexure lordship, it is from this
On what basis he is making such statement? It was available.
it is not apparent that that was available.
No, sir, he is making a statement. It was available. It was available. It was available. But it was burnt in the fire accident. But what is the material to say that it was available?
But from the annexure lordship 3030, is of the impugned annexure lordship, which might learn has challenged. From that annexure lordship blacklisting order.
Blacklisting order नहीं है. So-called notice of blacklisting. There is no quantum of period has been stated in this so-called notice. We Lord may kindly see page 80, annexure 30. No quantum of period has been stated. आपको काली सूची में शामिल करते हुए अगले निविदाओं में भाग लेने से वंचित किया जाएगा.
Lordship will find from
page number
80 में Lord.
Take your
actually.
Take your seat. Just take counsel. Which is page number?
Annexure 32. Page 82.
Page
82. Annexure 32. 32.
Oh. And the read blacklisting order on
right. Sir. Yes.
Paragraph 3, Lordship will find before Lordship passing the blacklisting order, the so-called notice was given to him, but he has failed to file any reply to that query, Lordship.
But dispute is that he has filed and the
Lordship, the letter number has been given. This Lordship annexure.
Letter number of what?
793.
This is so-called notice. Correct? Whether it has been communicated to him or not.
My Lord, that has been communicated.
Sir, counsel, will you take your seat or?
But paragraph 3, Lordship will find, Lordship, in spite of the issuance of so-called notice, he has failed to file any reply.
Sir, what is the material to show that this has been communicated to him?
Time may be granted.
Further
2 weeks time may be granted.
Why?
Whether
records have been burned.
Lordship, that is.
Whether criminal proceedings have been launched in respect of burning records.
My
Lordship, that is.
That
No, it's declined. This office has received the reply amount. If 2 weeks time is granted, what are you going to do?
Let's say from the material.
No, records are burned. Where do you get?
And this is, let's say, also the my contention is, let's say, this is appealable order, let's say. This is appealable order.
What order?
Annexure 32. This is appealable order, let's say.
Appealable. No, but notice does not stipulate that number of years of
But see,
the law. If we grant 2 weeks time, are you going to improve the things in the absence of record?
Lordship, probably I will Lordship furnish law.
How?
Because Lordship, the specific environment has been, the notice has been given to him.
According to him, he has submitted reply.
But he has failed to file any reply.
Correct. That is your submission. But he says that it has been submitted. He is now producing the RTI information. Your assistant engineer has given material stating that it was available.
Lordship, this is the position. This is the position, Lordship.
This is the position. Then why are you asking for 2 weeks time?
Because Lordship, the environment is
In the absence of any material, how assistant engineer will say that? Just for RTI. No.
Correspondence counsel. Let this public information officer, assistant engineer, file his personal affidavit. What is meant by that saving of the letter? Whether he is telling about receipt of the information under Right Information Act, that request or the letter of the
More there is no created specified in the blacklisting order.
That is
And also to argue on the point of termination order,
Sir, first one by one we have to go. Whether you are according to you, you have solicited your reply. They say they are not. That is required to be overcome, no? Then only will go whether specific notice is there or not.
FIR is there, lecture, I trace, 10 like supplementary, all records at one, we have to go.
At your instance? Burnt at your instance?
No.
By the contractor?
नहीं, contractor का है, contractor का नहीं, डिपार्टमेंट में भी आ गया था।
Today order dated 14th of March 2023.
Not 10 years.
Petitioner was
something is wrong with you.
Petitioner was
You learn from senior advocates. Learn from senior advocates, mister, how to behave in a court.
The petitioner was given opportunity furnish the proof that in Excel 31 dated 4th of September 2020 had reached the office of the Engineer-in-Chief, Rural Works Department, Patna. Stop. In compliance thereof, supplementary affidavit has been filed on behalf of the petitioner, wherein a letter from the Public Information Officer cum Assistant Engineer of the Office of Chief Engineer has been annexed as Annexure 35, which is dated 27th of April 2023. The perusal thereof, it appears that there is some ambiguity about the fact whether the letter as claimed under Section 31 of the petition has been received in the office of the chief engineer or not. London Council for the Petitioner submits that the said letter was received by the office of the chief engineer and the information received from the PIO from assistant engineer acknowledges this fact. In this regard, the assistant engineer from PIO is directed to file his personal affidavit as to whether letter number so and so, dated so and so, has been received in the office of the chief engineer or not. And whatever information he has been submitted in Annex 35 regarding whether it is regarding the receipt of the letter or the receipt of the request for information. Full stop. These facts must be made clear in the affidavit. The affidavit must be filed within 3 weeks. This is the case after 3 weeks.
In the beginning, you mentioned Council filed a hard copy of supplementary affidavit dated 1/5/2023 and it is accepted.
In next case also I had confirmed law.
Same order.
Serial number 12, the Union of India versus Suman Kumar for the petitioner Sri Kumar Sinha.
The concerned CDC is out of station. The concerned CDC matter is out of station due to some personal difficulty. Maybe listed after 2 days.
Have you produced the compassionate scheme, compassionate appointment scheme?
Lord, this is a I have telephonic instructions that to rush out of town due to some personal difficulties. It's paid for 2 days.
Order dated 19/4/2023 is not complied. For compliance, release this matter. In speech, failing which adverse order will be passed.
I'm obliged to know. Serial number 13, charged 4 weeks, serial number 14, versus Ecosystem versus the State of
In the present case, my lord, this is with regard to a tender. Whereby the same has been thereafter tender process, which is with regard to supply of manpower, my lord, in excise department and registration department. The petitioner, the tender process started, my lord, on 27/11/2021, and the petitioner participated.
Providing what service?
Manpower, that is stenographer, office assistant, multitasking staff in registration department, and prohibition, registration and prohibition department.
Now, what has been ordered by 2/5/2021?
But the last order, the interim order, I was served the show cause notice, and the show cause notice, they say that I will be blacklisted but the numbers of year it is not mentioned. Annexure number P15, if may kindly be seen at page number 158.
Page number
158, annexure P15. The type copy would show at the last अतः प्राप्ति के 1 सप्ताह के अंदर, this is dated 1/4/2022. At the last paragraph, it is being said.
Why you are not when giving the typed copy? Why you are not mentioned the date? What is the typed copy? As it is, huh? Then
as it is. I'm extremely sorry. At the bottom. And my lord, second, my two submissions are there, my lord. Secondly, my lord, I give you.
What's the date of your reply?
5/4/2022. 5/2022. In the agreement at clause number 14, with regard to termination, it mandated that 30 days prior notices to be given.
Where is that?
Annexure P9, page number, relevant page number 97.
Clause number
14/14. 14 is, and after the first two lines, in any event other than the specified in clause number 14/14, where department may terminate the agreement forthwith. Department may terminate this agreement by giving first party, the present petitioner, 30 days written notice.
1/4/2022 notice. How many days time was given?
7 days. And third submission, my lord, that I gave my reply, my lord, by annexure number P16 at page number 159. And it was a 5-page reply that I have submitted, but they have rejected without considering my show cause reply. That I have stated in paragraph number 33 of merit application, and they have not reverted to the same. They reply in paragraph 27 in the counter affidavit that everything has been dealt in the preceding paragraph. And non-consideration of so cause reply. Kanti Sushil.
Page 163, last paragraph. Page 163, last paragraph.
Page number 163, last paragraph is the where the agency through the authorized signatory so and so.
Yes.
So cause letter dated 5/4/2020 that since the work tender was given to the agency and not to so and so, the proprietor of the agency should not be penalized for the wrongful act of Abhishek Kumar Padhai, which is done in his personal capacity. Further, it is stated that none of the staffs of the agency were found with the alcohol at the time of seizure, and the arrest of the proprietor. So the illegal act should not get to the agency as a whole. It is further assured that the registration and selection of manpower will be done within a week. Next page. Where the department carefully examined the reply to the so cause of the agency and has come to the conclusion that the info system is headed by the proprietor and any action decision on behalf of the agency is taken by the proprietor. So where the proprietor has breached the Bihar alcohol prohibition policy have its repercussion on the agency. Two, as the agency does not have the mind of its own and the same has to be derived from the act or mission of the proprietor. So I gave my reply. If my reply may kindly be seen at annexure P16, at page 160, it's a 9-column reply, that I have submitted. Page 160, the relevant part I am referring to, and they have not considered this fact. They have only observed that since the proprietor.
What has not been considered?
Column number
9-column reply.
Yes, yes, page 160.
What is that which was not considered?
Column number 7. Page 161. Column number 5.
5 or 7?
5 and 7. In fact, they have, in the show cause notice also, it is a very vague show cause notice, where they say that the proprietor was arrested having liquor in his house and was showing interest in doing the work. And therefore, why not should be blacklisted and the personal security and the should be forfeited of 14 lakhs. And when they're passing the order, they have blacklisted him for a certain period of time. That was not part of the show cause notice. But the Kranti Supreme case also dealt in para 47.
Manpower supplied by petitioner. But he himself is not discharging any work. Sitting. Every supervisor using contact with the terminal. One can understand during the course. Into our before giving certificate and demand about yes, madam.
Lordship, we have already filed our counter affidavit in this regard. And you
It's on the mic.
Sorry, Your Lordship.
It's on the mic.
Okay. Your Lordship, we have already filed our counter affidavit in this regard. So the case, Your Lordship, the agency of the petitioner was
Proprietorship
for providing manpower and the staff of the registration department. From the improved order itself, it is evident that he, apart from the consuming legal by the proprietor of the company, has also not fulfilled the requirement for which the agreement was made. He has not provided the power required within the.
What is the second requirement?
The main objective of the agreement is to provide manpower.
He has supplied or not? Where have you stated that he is required to supply these many manpower?
That's in the second paragraph of the improved order. May I read, Your Lordship? Despite several reminders, which is out to our life to provide. Your Lordship, I am reading the third paragraph. Where the department issued the office order number 113 dated 21 to 2022 and office order number 1314 dated 2/3/2022 to the agency to provide a total of 189 manpower within a period of 2 weeks to the respective division of offices. However, even after the lapse of 1 month, the agency failed to provide the list of selected staff to the respective section. Moreover, it has come to the knowledge of the department.
Alright, you can take this ground, this defect. But if he is consuming liquor at his residence and if he is involved in the Prohibition Act or something, how is it relevant for terminating the contract or blacklisting him?
That is not the scope, but the objective.
Then why are you invoking extraneous material, which is not relevant? If he is involved in his personal capacity in a violation of Excise Act, how is it relevant for the forfeiting the EMD and other things?
Your Lordship, otherwise after he is not complied with the requirement of the
but extraneous material has been taken. How is it relevant? Your agreement says so that the contractor shall not involve in offences under the Excise Act and all.
That is not there, but the requirement to.
Anyway, we will set aside and remand the matter. You take first steps. Because there is a violation of 14.14 and the notice is not specific.
Your Lordship, I just want to point out on page 96, Your Lordship, of the agreement. Clause 11.4. It is specifically mentioned that if the event of the agreement being terminated or resigned due to non-compliance of any of the clause of condition. 11.4, Your Lordship, at page 98. In the event of the agreement being terminated or resigned due to non-compliance of any of the clause or condition of the agreement by the first party, the performance guarantee shall stand forfeited in full on issuance of notice of termination of absolute.
That is
discretion of the department.
You can't have such discretion in the light of apex court decision in the case of what is that airport authority.
Lordship, clause 41 and 90 is also there, which is specifically your Lordship.
Sorry, madam. Yes, take up. The instant petition. Petitioner has prayed for the following relief. The petitioner was a success there insofar as providing manpower in the Department of Excise and Education.
Registration,
prohibition, Excise Department. During the course of contract, respondents have noticed certain defects in executing work. In this regard, number of have been number of office orders were issued so far as fulfilling the required manpower in terms of the agreement. The same has not been rectified by the petitioner. Further, he is involved in offences under the Excise Act. In regard, he was arrested on 24th. While taking note of the respondent issued notice on 1 for which the petitioner submitted his reply on 5/4/2022. Thereafter, an order of forfeiting the 14 lakhs and blacklisting for a period of 3 years, which would be in vogue 31/3/2025, has been ordered on 2/5/2022. Hence, the present petitions. Then counsel for the petitioner submitted that notice dated 1/4/2022 not in compliance to 14.1.4 of the amendment. Further submitted that government notice that the proposal forfeiting of 14 lakhs and the blacklisting for a period of 3 years is 31/3/2025. On these two forms, it also merely he was involved in offences under the Excise Act in his personal capacity. The two the alleged incident taken place since such incident cannot be taken note of for the purpose of forfeiting and blacklisting the petitioner. in the absence of any clause under the agreement. The contractor and counsel for the respondents resisted the aforesaid contentions and submitted that has failed to comply various clauses of the agreement insofar as providing or supplying manpower. In this regard, 2 office orders were issued on 21/2/2022. The same has not been complied by the petitioner. Jhatka is involved in criminal proceedings. Same has been taken note of while issuing show cause notice on 1/4/2022 and proceeding to forfeit 14 lakhs rupees, forfeiting of 14 lakhs and blacklisting him for a period of 3 years. By order 5/2022 is in order. Therefore, it is also submitted that clause 7.4 has been complied. Before heard the consensus for the respective parties. Before adverting the factual aspects of the matter, it is necessary to reproduce 11.4 and 14.1.4 of the agreement, which reads as under. No doubt, the respondents are empowered to invoke 11.4. At the same time, they cannot brush aside the judicial pronouncements so far as providing specific notice for blacklisting a contractor. That part, they have violated clause 14.1.4. They said that notice stipulate 7 days here to file is replied. On the other hand, 14.1.4 specifically provided 30 days notice, 30 days written notice. Further, we notice that specifically insofar as the blacklisting for a period of 3 years. The respondents have taken extraneous material insofar as involvement of the petitioner. The criminal proceedings for the offense under the Excise Act. If a contractor is involved in criminal proceedings, that event, there is no clause in the agreement. The extent that a contract would be terminated and the contractor would be blacklisted. Therefore, the respondents have taken extraneous material here. In the light of these facts and circumstances, on short ground, the petitioner has made out the case that the notice is not in terms of clause 14.14 and notice is not specific to the extent of blacklisting for a period of 3 years. 31.3 according to the petition, according to the respondents to initiate appropriate proceedings and in accordance with law The concerned authority is hereby directed to take note of judicial pronouncements insofar as blacklisting, how action is required to be taken. In this regard, UMC so and so read with isolator and so. Apex code taken note of as to how authority was required to proceed before blacklisting a contractor. In this regard, the following points are required to be taken note of by the concerned authority before proceeding further against the petition. Further action shall be taken against the petitioner within a period of from the date of this order.
Contracting for 2 years. Can be months.
Why 2 months? Sir, they have to analyze facts, they have to issue fresh notice, and they have to obtain reply. In 2 months again, you will come and say, no breathing time was given. Hard copy. In the beginning, you mentioned hard copy of the counter private accepted.
Worship, if my Lord says, please be ordered to enter the whole plus 2022. And then the other order is there, minutes. The other order is of 11th and 10th of November 2022. Also, the issue is very short and simple. That what happened that I had executed I used certain mines and minerals, and I submitted M and challans to the my jurisdictional executive. He got it verified, and he was not making me the payment, refunding the payment of royalty about 1.36 lakhs. Then I kept on writing. He said that I am writing the mines department, they are not refunding, so therefore I am not ready. I came before this honorable court, and this honorable court directed the principal secretary of the department to take steps immediately, and within 3 weeks, failing which interest was directed to me.
How writ petition is maintainable?
In this case, yes.
You are challenging the action, proposed action to large FIR. One thing. Second thing is recommendation for permanent blacklisting. First one, you have an remedy before under 482 of CRPC. Second, relief is concerned, it's a premature.
Yes. Now it was followed by the second petition. Now they issue the super.
That is stating that the present petition is premature, and
if my Lord says please to see the second petition, both of them have been
blacklisting has been ordered.
Yes, the so-called notice has been issued for the state by any competent authority.
That will examine independently. We will decide this. This is premature.
Yes, to that extent, I will
and counsel for the petitioner, after arguing for some time, seeks permission to withdraw writ petition number 14236 of 2022. Accordingly, writ petition stand dismissed as withdrawn.
So it is 11407.
Double
407.
407.
Yes. everything is collected. So therefore, now the second case is one
show cause notice issued by incompetent authority.
Incompetent authority. It is issued by the deputy secretary of the department. I have made categorical statements in para 38, 39, 40.
What is their counter?
There is no counter. They say that it is no statement. And secondly, beyond the rules itself, because they have relied upon 11%.
Incompetent on that ground we will set aside. Yes, who is for the respondent? State.
Yes, my lord.
हाँ?
12949.
दोनों मेरे पास
Deputy Secretary of which department?
Water Resources Department.
आपका केस कौन है?
Water Resources Department, they have filed counter?
Yes, they have filed.
Water Resources Department, there is no principal secretary. In this case, my
No, it's not like that. We'll assume that that has been passed by principal secretary. Where is the material to show that the principal secretary has
secretary is there, my lord. Principal secretary says there is not available.
Even the principal secretary,
competent authority according to you.
The registering authority that is here.
Secretary, my lord.
So where is the material? Secretary is the competent authority. Sir, right now only he has stated that he is an incompetent authority. You have to counter with material. The secretary is the competent authority. Show us.
The principal secretary is there.
Sir, please don't make a overall and very vague statement. You being a senior counsel, you file a affidavit stating that the principal secretary or secretary is the competent authority with material. Anyway, we'll have the affidavit. Yes. Principal secretary or secretary / secretary Water Resources Department, Government of Bihar by directed to file his personal affidavit as to whether secretary is competent authority to issue so far as blacklisting the contractors or not. The blunt counsel for the submitted that the competent authority is the registering authority
Under the Bihar Contractors Registration Rules 2007.
Take the title.
Clause 4.
Clause 4 is extracted as under. Same shall be the aforesaid contention of the petitioner shall be taken note of by the secretary, the principal secretary of Water Resources Department before filing his personal affidavit as to who is the competent authority. Such affidavit shall be filed within a period of 10 days. Release this matter after 2 weeks.
For blacklisting, the executive officer is authorized by
put it in right
about the I'll
the other connected matter?
The other connected matter is next party inquiry report and is followed by the same. And here
Clause 4, sir.
Clause 4.
Bihar Contractors
Registration 2007.
Sure, sir. बैठेंगे अभी क्या? 10 मिनट.
एक बात ओवर नहीं है
क्या सर?
23 बात ओवर नहीं है
23 में 2 weeks हो गए.
हो गया है
सर
23 हाँ
17 ठीक था.
सर
10 मिनट का 10 मिनट का 32 आप दे रहे हैं. 22 लिखा हुआ है.
लिख दीजिए 23
सोलह का तीनों दे दीजिएगा सर, 16 का तीनों। अभिषेक जी 16 में 3 था, 3 में एक विड्रॉ हो गया ऊपर वाला, तो विड्रॉ हो गया तो आज 2-3 रह गया। रिलीज 2 वीक्स सेम ऑर्डर है। हाँ सेम ऑर्डर।
उसका सर वो लिख के था ना, क्या था सर, कौन सा क्लॉज था 4 का, बिहार कॉन्ट्रैक्टर
है,
कौन सा क्लॉज?
बिहार कॉन्ट्रैक्टर्स रजिस्ट्रेशन रूल्स 2007 क्लॉज 4,
बिहार कॉन्ट्रैक्टर रजिस्ट्रेशन
रूल्स
2007
क्लॉज 4। 22 नहीं है क्या? 21 अर्जेंट है, 2 वीक्स 2 वीक।
ठीक है सर, सीरियल नंबर 34 में भी तो क्या है?
एक रुक जाए सर,
हम कहाँ आ रहा है?
34 में टाइम हुआ है
कितना?
एक सप्ताह।
होगा तो अप्रोच करेंगे, 3 बार से टाइम लेके भाग जाते हैं, 3 बार से 2-2 सप्ताह लेके भाग जाए
ऑफिस में। हाँ डॉलर चाहिए, जैसे हम बोले थोड़ा पॉज ले लेंगे, प्रोटेस्ट कर
आ जाएंगे।
बचा हुआ है।
क्या नहीं जाता
क्या हिमांशु जी?
सर बढ़िया सर, सब
8 9
उसको काम झूठा ले लिया पहला, हमसे काम का ले लिया।
फोटो उठा रहे इसने कोट में बदतमीज बनाया है भाई साहब, मैं तो बाहर से लेके
काम बनाया तो बहुत बेकार है, सही बात है। इधर देखो नीचे साला तो खुल जाता है।
तो बाहर का लूंगा कंपनी वाला 5,000 4,000 का, तो वो भी आता है एरो वगैरह आगे पे।
हाँ, तुम तो ले सकते हो, हम लोग के साइज का थोड़ा सा इशू है,
मीडियम और ये
नहीं तो हम बनवाएंगे लेकिन अपनी बढ़िया ट्रेनिंग से।
मेन चीज है आपका
सही लगता है
ना, इसके साथ
ये मेरे भी ऊपर चढ़ा हुआ था, भी नीचे देखेगा मजा हो जाएगा।
तीनों फाइल में लिखा हुआ है 17,922।
नहीं सही कराएंगे उसको, कि सब उसका 1,000 रुपये हम लोग रखे हैं दूसरे।
तीनों की है।
हाँ इसमें ऑर्डर नहीं है,
तो पहला में दूसरा में
उसको मेरे तीसरा बैटरी में मिल जाएगा।
हो सकता है कि और नहा चुका होगा, तो अभी डिस्पोजल में दिए हैं तीनों फाइल।
तीनों डिस्पोज होता है।
हाँ तीनों डिस्पोज होता है, क्लोज है। हाँ
तो तीनों डिस्पोजल में बेसिस हम देखा गास किससे डायरेक्ट डिस्पोजल में डायरेक्ट
हम लोग का गाड़ी तो नहीं होगा, लाल पटल तो नहीं यहाँ का, इसमें तो
इसी में है
पार्टी होगी। नहीं मतलब लोग ये कर रहे थे ना कि टच उस तरह से नहीं फील आता, कोई दिक्कत नहीं है भाई, मस्त कहीं पता भी नहीं चल रहा। ऊपर नहीं ना फिर
क्या होता है सर?
ट्विस्ट हो जाता है क्या?
ठाकुर जी
हाँ हैं हमसे की बात ही लोग हाँ कंटिन्यू रह गया यार
क्या नाम था इसका चुप डाला कैसे करते हैं इसको दबाए रखते हो और इंस्टॉल हो जाते हैं
यहाँ से नहीं
यहाँ से नहीं आएगा यहाँ से आएगा मुझे देखना पड़ेगा ना यहाँ पे जाके ऐसे ना टी टी पर टच ये ऐसे अब तो हो जाएगा होएगा टॉकिंग टॉकिंग कितनी डाली है बच्चे 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 के लिए बच्चे सबके इसे कर देखिए क्या नाम लेगा
कौन है टॉपिक उसको डिलीट कर दो
कैसे जानते
वो भी कमरा में नहीं है वो इनको सबक सिखा देगा
अरे अरे थर्ड पार्टी से पूछा ना बीच में एक बार इनको समझ नहीं आता
ऐप ज्यादा होने से फोन हैंग करता है ना ऐप ज्यादा हो जाता है तो फोन हैंग करता है
ऐसा कुछ नहीं होता ऐप ज्यादा होने से फोन नहीं आता स्टोरेज कम होने से उसको फोन हैंग होता है
तो स्टोरेज ज्यादा होगा रैम रैम का स्टोरेज ज्यादा होगा देखो
रैम का नहीं रोम का रैम का स्टोरेज उतना ही जाएगा चाहे फट जाएगा रैम कभी भी बड़ा ही होगा टाइम जैसे
साले को फिर क्या करें यहाँ से डिलीट करें वीडियो ऑडियो ना
हाँ वीडियोस वगैरह इंटरनल स्टोरेज डिलीट कर सकता क्या करें यार
ये है मेरा बेटा उठा अपना चूसता है पैर का राइट
राइट हैंड पैर को भी चूसते
पैर का है भाई
अच्छा पैर क्यों
देखो ऐसे पकड़ा है ना इसको ले आके मुंह में अपने नाक लेता है देखो पोजीशन देखो पकड़े है ऐसे भाई भाई कौन
ऑफ है अब ऑफ ही रहेगा अब आप यहाँ से कुछ भी कर लीजिए ऑफ ही रहेगा
Serial number 17, Sanjeev Kumar versus the State of Bihar for the Research Chief Sanjeev Kumar.
Impugned order is annexure 15 at page 36, my lord. By which representation in pursuance of the
page 36, annexure 15.
Page 36 and the same annexure has been annexed as annexure D1 at page 24 of counter affidavit also. In my petition it is.
No sir, in your petition and
my petition
in order.
That is annexure 15.
Page 36.
My lord.
Why the same is repeated? Why are you enclosing the same document?
That I have stated. And this honorable court has directed me to file a representation before the empowered and standing committee, and I have submitted my representation, but without considering the same, this order has been passed by the court.
Against this, you have a remedy of appeal before the tribunal?
Not tribunal. We have remedied. Actually, I had come before this honorable court, and this honorable court has given me liberty to approach the empowered standing committee, and accordingly we have approached the empowered.
Correct. Thereafter, there is a remedy before the appeal. No,
no stage.
Where is that contract rules 2007 or something?
There is a appellate tribunal, tribunal also.
Go and approach tribunal. Why have you come here?
Actually, my submission before is single folder.
Brother is saying section 9.
That is there, my lord, but
we can't bypass.
Actually, जब dispute कुछ, whenever there is some dispute.
Here there is no dispute.
I am submitting that I have been my contract has been decided only on the region that I have not completed that work in time. I have given reasonable explanation, my lord. But that
has not been considered by
my lord. That is my submission. Kindly see, I have given reply, my lord. In reply, in pursuance of
No, where is the material placed by you before the standing committee?
That is annexure 17 in my supplementary affidavit, my lord. In my reply to counter affidavit, my lord.
COVID period. And
how it has been completed.
My lord, I have given a detailed explanation. Kindly, in writ application, I have annexed only receiving, but in this
but you were given time of 6 years to complete the work.
No. 3/12/2020, my lord.
Yes.
In the meanwhile, COVID came. That last time was given to me, my lord, and I have given
last extension.
Extension 30/12/2020.
30/12/2020.
My lord.
Up to what date?
That is 30 by annexure. I will show, my lord.
Up to this date.
My lord. Up to this date, I was to complete. But in the meanwhile, in the year 2020, there was COVID-19, my lord. And I have regularly given application because of this. I am.
How much work you have executed?
90, more than 90%. I have specifically stated in my representation as well as in this. Writ application also.
10% has been executed by third party or?
No. Till now, nothing has been done. I am ready to conclude that only because that there was a official order in 2020.
What is the nature of work?
Road construction. My lord, I have given that I have completed grade 1 work, grade 2 work.
Yes, Mr. State Council, allow him to continue. We'll fix a time limit.
My lord.
6 times enough has been granted. years time.
Correct. Now at the fag end of the period, on 30th, he was required to complete on 30th December 2020. Now, in the meanwhile, on 20th March 2020, COVID-19 was affected.
Ground taken by him.
Correct. Now we can explore this and we'll ask him to complete the work within 3 months or 4 months. What he was on? You are not allowed to work, execute the remaining work after March 2022.
After March 22, my lord, 30/12/2020, I have given a representation explaining that due to this I am not able to complete the work. Jiladhiya DM के आदेश से, by the order of district magistrate of Gaya, the lease of all the leases were stopped, cancelled, and only after the order of this honorable court that was revoked, my lord. And now we are having no problem, my lord.
The order was passed on what?
August.
For how many years?
5.5 years.
No. That period is 3 years or 4 years.
What was the initial period of contact?
My lord, I stated, my lord.
2015, lordship.
The work was allotted to me, my lord. In paragraph 5, I have stated that work was to be completed by 4/12/2015. And the reason for that, why it was not completed, I have explained in from paragraph number 6 onwards, my lord. And thereafter, time was extended.
What is the impugned order?
Impugned order is Annex 1 at page.
Blacklisting or what?
Pardon,
blacklisting or forfeiting?
No, not blacklisting. Only my work contract has been decided and my all security deposit and other deposits have been forfeited.
State Council will
another
grant 3 months time to complete.
Let's see, another ground is, he has taken the another ground. Let's say the due to anti-social element, he did not complete the work.
Now
anti-social element, he did not complete the work.
That was initially
you have condoned the delay and extended up to 30th December 2000.
My lord, one thing, my lord had just
at the initial time itself, 2017.
My lord, I'm sorry, my lord has asked me whether I have been put under a blacklist or not. In prayer portion, my lord, I have directed, by impugned order, they have directed me to be put in the blacklist and the earnest deposit, security deposit and extension deposit have been seized.
Proposal only?
Only proposal.
Take on the instant for the following relief. Normal course not have interfered with the action of the respondent. So, however, However, having regard to the, however, unavoidable circumstances, there was a delay in other words, it was beyond the control of the petitioner. Facts of the case are that an agreement was entered into for execution of road construction on April 2014, and petitioner contractor was required to execute the contract work before 4 months of completion. So he could not complete for various reasons. It was completed by the respondents department and proceed to extend time for execution of work. So the last date of extension of time was on 7/8/2020, by which the petitioner was asked to complete the execution of work before 30th December 2020. The petitioner contractor could not execute the balance work due to COVID-19. It was affected the human life from 20th March 2020, and it was standard operating procedure was issued by both state as well as central government, and it was in vogue till 20th March 2022. Therefore, the extension period for execution of the work is during the intervening period from 20th March 2020 and 20th March 2022. So, taking note of factual aspects of the matter, it is not appropriate to take action against the petitioner in the light of COVID-19. Therefore, the petitioner has made out a case so as to interfere with the impugned order dated so and so, and it is set aside. So, the petitioner shall petitioner shall execute the complete work in a period of 3 months.
4 months कर दिया जाता है.
3 months from great. 3 months from 15th May 2023, failing which the respondents are at liberty to initiate action in accordance with law.
Serial number 18 is adjourned for 2 weeks. Serial number 19, the Union of India versus Kumar Rajneesh for the rating of English market.
This has a I want to take, but the railway board has railway board has issued a circular where they have given an option to opt for the old pension scheme, and relying on that, the ECR, Eastern Central Railway, has also issued. I'm bringing all things on the record here, Lordship. In the light of that, it can be disposed of. Lordship, this is the facts and the brief are the petitioners were recruited when the new pension scheme came into vogue. They moved before they wanted to revert back to the old pension scheme. Was
there any option?
No, there was no option.
Then how can you resort for old pension?
No, now the railway board has given them an option to they can opt for the old pension scheme. I'm bringing that on the record. Your Lordship, it may be taken after 2 weeks. Your Lordship may examine it. And subsequent letter issued by the East Central.
In terms of later policy decision of the railway authorities, how the writ petition is maintainable?
No. That's why I'm saying. Subsequent development while the pendency of this writ application, railway board has taken decision that is of Your Lordship. If I may give you the.
So that is in favor of the respondent.
Yes, Your Lordship. That
what is the date of the policy?
10th of March 2023. And subsequently, there has been letter also been issued by the East Central Railway, so they can opt for it. And this is that is some time limit is given, Your Lordship, that within June 2023.
No, what is the directions of the CAT?
The CAT was to that they should revert it back to the old pension scheme. But Your Lordship have stated on the very first day, in the light of the Honorable Apex Court's order, and notices the issue.
Anyway, the railway authorities have taken a policy decision.
Yes. I want to bring that on record so that everything is complete. Not on my only oral.
With reference to 10/3/2022 railway policy decision, while giving option either to opt for old pension or new pension, the present petition do not survive for consideration.
No, my humble prayer will be, Lordship, let it be taken up after 2 weeks, Lordship, and then I'll bring it on record so that everything is on record here. I'll serve a copy also upon him.
On counsel for the petitioner, instruction submitted that the railway authorities / department have taken a decision to such of those employees who were appointed subsequent to the new pension scheme were given option on 10/3/2022 either to opt old or a new pension. The light of this present petition may not survive. However, we intend to bring certain documents on record. Release this matter after 2 weeks. It is made clear that no further time will be granted.
10/3/23, Your Lordship.
10/3/2023.
23, not 22, Your Lordship. I'm obliged.
Serial number 20 is adjourned for 4 weeks. Serial number 21 is adjourned for 2 weeks. Serial number 22, this was Vijay Engineering Works versus the State of Bihar for the National State of Kumar.
I have received the counter from the state, and the state has said that we have not given to the respondent whom I had made a party, and they have allotted to some another.
But Needham printers have not been given the work, and I have been implemented as a party. And since this is not being uploaded in absence of correction in the daily party position, my lord. So hard copy is there, counter is there, my lord. It was entrusted to another party.
So my humble submission.
Better withdraw this petition and file a fresh petition. We can't permit you to go on adding respondent after respondent. In fact, now you are required to pay cost to the 7th respondent.
By way of supplementary, if you also grant by way of supplementary affidavit, I will file the
supplementary. You have filed supplementary.
No, my lord, I am just.
Then we will not permit you. Please take up.
Without leave, I have not.
Can I find the counter affidavit?
Why you want, sir? If you are entitled to any fees, you can file it.
Yes.
You are entitled to fees. Sir, you are representing private party. You are representing private party, therefore no interest.
For justification of my appearance by the private party, I have appeared.
Counsel for the seventh respondent filed a counter affidavit. The same is taken on record. Today, learned counsels for the respective parties submitted that seventh respondent is not the appropriate and necessary party. The work has been allotted some other to some other third party and who is not before us. Therefore, the present thanks disposed of. Reserving liberty to petitioner to file a fresh petition arraying the proper respondent party.
Obliged.
Serial number 23 is adjourned for 2 weeks. Serial number 24 is adjourned for 1 week. Serial number 25, Vivas in Brussels, the Union of India, for the petitioner Sri Rakesh Kumar.
This is the petition. Way of PIL, this one petitioner came before this.
Where is the order?
My lord, page 15, my lord. Page 15.
1-5.
My lord. The relevant direction as page 19, my lord.
19 or 20?
No, 19 and 20 both, my lord.
What was the specific direction?
To represent before the circle officer who shall, after the representation, consider and dispose the material within 3 weeks, my lord. Within 3 months.
Concerned representation.
My lord. Thereafter, in pursuance of the representation.
They have not passed any order?
My lord.
What is the date of your representation?
My lord, 10th of August 21, my lord.
The respondent has to consider.
My lord, respondent number 8.
Respondent number 8.
My lord, the circle officer. My lord, the
representation is given to circle officer.
My lord.
Lord, in this case,
Who is representing?
Mine. Lord, pursuant to direction of this honorable court in writ application, my lord, Sir P2, case 23, my lord, encroachment. Case number 44 of 2021-22 has been initiated and substantive order has been passed. Notice has been issued, and thereafter I have no instruction, my lord, for bringing on the outcome of